Biometric data contains information acquired from individuals which can be used to identify them. This raises issues of privacy and data protection. Our panel, Biometrics and Privacy, will discuss some of these issues, addressing mainly the private sector's challenges. So, biometrics, privacy, regulation, and the industry, how does it all come together? We will try to address that at the next panel. I would like to welcome our panelists, Professor Michael Birnhack, an Associate Dean for Research at the Faculty of Law, Tel Aviv University. Dr. Adi Gillat, advocate, founding partner at Hirschfolk Law Office, and leading its IP, IT, and tech transactions practice. Advocate Limor Shmerling Magazanik, Director of Strategic Alliances at the Israeli Privacy Protection Authority. Also, I would like to present and welcome Advocate Naama Ben-Zvi, the legal advisor for the Identity and Biometric Applications Unit, to moderate the panel. Naama has a unique expertise regarding biometric and privacy and is a member of the Privacy Work Group at the Biometrics Institute. Thank you.
Thank you. Is it on? Do you hear me? Okay. So thank you, Yasmin. Good afternoon, everybody, and thank you for coming back just after the short break. Just a quick question. How many of you spent the last 2 days in GDPR sessions here in CYBERWEEK? And you still came back for more. So, okay, that's great. In the next 30 minutes or so, we will try to give you some new angles and to address the practical issues that rises from the mixture of biometrics and privacy, since one cannot go without the other. So it is acceptable to say that biometrics are different from other types of information. It can't be revocable, as Roy's mentioned it before. And it also often used as a key to guard other important and sensitive information. So it has a dual meaning in that perspective. It is sensitive, and yet in recent years we see a growing usage of biometrics for many, many purposes. We've seen good examples here today. And what was once in the sole control of government and law enforcement is now a part of our everyday life and quite popular. And so this is just one of the trends we are encountering in the world of information technology that raises privacy concerns. And we will be focusing on the new EU regulations that just came into effect last month. The GDPR, those initials admired by some, but intimidate so many others. So before we start, just a quick reminder, please go to BIST 2018. There's a link there to a very short 4-question survey we sent you. We would like you to participate because we're going to deal with that in about 20 minutes. So just get on board and do it. It's only going to take a few seconds. Are you doing it? You're doing it now. Okay, so let's start with an overview. What are the challenges when it comes to biometrics and privacy? What are the concerns? So Michael, can we start with you?
So good afternoon, everybody. I've been listening to the sessions in the morning, and it helped me crystallize, to myself at least, some of the issues with privacy and biometrics. And the main issue is that privacy is not on the main checklist of the industry. Some of the previous speakers have mentioned privacy as the last bullet. Some have not mentioned it at all. When asked, some said, well, that's the legal, or that's the data protection officer, or someone else. Biometrics has a bad reputation among the public. I think so. And this is a challenge for the industry and for the governments who wish to use it. Now, why is this bad reputation? Because biometrics can be extremely efficient, right? And we've seen examples, and those of us who experience biometrics in our daily lives know that it can be efficient. And there's some hygiene issues. Okay, I understand that. And people are scared of identity theft. That's, a motivation to use biometrics. But nevertheless, why don't people like biometrics that much? And I think part of the reason, hypothesis to be explored by someone, is that biometrics is a black box. We give our biometrics, or they are taken from us, sometimes without us noticing, like facial recognitions in football stadiums, etc. And we do not know what happens with the data. Someone uses it. We are not exactly clear for what purpose. We do not know whether the data is transferred to third parties, and if so, to whom. We do not know for how long the data is retained, what can that data be used for, etc. There's a sense of loss of control. And I would suggest that those in the industry and the government who think that the privacy is dead or something like that, that's a huge mistake. Privacy should be taken into consideration, not just because of the GDPR and the legal requirements. Privacy should be taken into consideration at the beginning in the design of various systems as a feature, as a specification, as a user requirement, if you wish.
Limor?
So from a very non-academic, let's say, sentiment, I think that biometrics has some sort of psychological influence on people. I think we could see that in Israel with regards to biometric information. It has, people grasp it as something more intrusive when whoever collects biometric data about them. I think that this psychological perception indicates something that is deeply connected to the privacy risks that are entailed with biometrics, since the biometric itself has privacy risk if someone gets hold of them and is able to use them in a way that harms us. It's also a privacy risk that is intrinsic to the biometrics, since from various biometrics, other data, personal data about people can be inferred. So by acquiring biometrics, you are sometimes, and I think that the technology development would take us even closer and closer to that world. You can infer other personal information about people, and this is something that worries people. The third reason is that biometrics are a key to achieve more personal information about us, since we use biometrics to open our bank application and to identify to the HMO application and order drugs and order appointments to doctors and so on and so forth. So we have three different vectors where biometrics is extra sensitive in comparison to other personally identifiable information. And I think that even if the public is not totally aware and understands that, psychologically we feel that there is something here that is especially important to us. And I think that the public sentiment nowadays with respect to privacy has changed, and consumers are growing more and more aware of their privacy rights and privacy concerns. And various scandals in the data protection world have created people who are requiring and demanding more and more privacy protections. So I think that it'll be good for business, for the industry as a whole, and for the biometrics industry especially, to be more aware of the privacy connections for biometrics.
So Adi, do you have anything to add? Like, let's say it's just so convenient, isn't it?
Yeah, so I actually want to say, can you hear me? In any event, oh, now yeah. So I have two things to say on the kind of other side of the spectrum. So two things for us that often come up from the industry perspective, from the startup perspective. So number one is, why often the question is, how and why is the data that we collect not biometric at all? How do we get out as a startup of this bucket, which is extra sensitive, psychologically disturbing, has a big light from the regulator? So a lot of people from the industry perspective don't want to be in the situation of defining their data as biometric. And the definition of biometric is tricky and is a little different, and I think we'll touch upon it a little later, than other types of privacy, of personally identifiable information. So that's number one, so one aspect of the other side of the coin. And another aspect from that other side of the coin is that if you do believe that you have, from a startup perspective, data that is biometric, you actually see yourself as the protector of privacy. Because my technology allows you, the consumer, to protect your other personal information. So like Limor said, if we have strong ability to protect our bank account, where is the bigger damage? Is the bigger damage that somebody's taking my fingerprint and holding it? Or is the bigger damage for my financial information to be more vulnerable, lacking that ability to protect it through a key that is biometrically mine? So from the industry perspective, there is a sentiment that is that finds the overprotectiveness or the negativity towards biometric data a little bit concerning or worthy of unease. So that's from the other perspective.
Okay, so mitigating those concerns. Concerns means regulations, as we all know, and we also know that regulators are usually a bit slower than technology, and it took about 20 years to come up with a new updated data protection regulation. So we're just going to dive into the GDPR. Why is it a game changer, GDPR? Such intimidating initials. So I would like to...
Well, I can say just 3 S's: scope, sanctions, and subcontractors, and perhaps Michael would like to elaborate. Yeah, but the scope, the territorial scope, the very ambitious definitions that it applies wherever organizations are targeting Europeans, and not only if they have been established within Europe. So that's one thing. The sanctions are very high and severe. Monetary sanctions up to 20 million euros or 4% of the global turnover, whichever is the highest, and that is something that intimidates even internet giants. And I think that one of the things that made it well known all over is the fact that it also requires not only the controllers, not only the organization itself, but all of their subcontractors, outsourcers, service providers, whomever they be, and wherever they're located, to be GDPR compliant as well. And this is something that I think has created the very large attention that it received.
I would like to add that other than the 3 S's that Limor has mentioned, for me the #1 innovation of the GDPR is that the law recognizes its own limitations. The GDPR adds new rights and new duties on, addressed to the data controllers, etc. But the law also turns to non-legal mechanisms and requires them, first and foremost, within the organization and technology. So this is the requirement to appoint a DPO, data protection officer. This is not it's a legal requirement to appoint someone like that, but the GDPR doesn't exactly say what the DPO should do. The GDPR further requires DPIA, data protection impact assessment, which should be conducted before a company or the government engages in a biometric or any other data protection related technology. And privacy by design, or data protection by design, which once again means that an organization, government or industry should think about privacy from day one, and not design first and then, oh, we have the legal department says we have a problem. The legal and privacy people, which don't necessarily have to be lawyers, they have to be involved in the process from day one. And in biometrics, it matters a lot. It matters whether we design the system with a match-on-card system. Is that enough? Do we really need a central database? That's one of the major debates over here in Israel with the national database, biometric database, and lots of other decisions, some of them big, like this one, match on card or central database, or smaller ones. So for me, the number one innovation of the GDPR, that it goes beyond the law and requires these various technological and organizational processes.
So, once again, I have a completely different view. This was, by the way, my view up until 3 weeks before May 25th. So reading the law, understanding the complexities, all of that are huge game changers. But it occurred to me a few weeks before May 25th that I found two other huge issues that are impacts of GDPR that in fact are outside of the GDPR. Number one, I call it inspiration. So GDPR has, and inspiration is a positive spin on what has happened. So GDPR has created a vibe in the industry that is far, far beyond the EU and is implemented by bodies like Google Play. So Google Play, inspired by GDPR for sure, published new consent rules little before May 25th. And this has struck the industry like a tsunami. And I can tell you from close experience, I have a client that was one of the startups that have, I admire them for the seriousness that they've taken this, for not un-Israeli-like preparedness several months before, not 4 weeks before, calling me, oh my God, what are we going to do? No, we've talked about it. We mapped everything. It was perfect. And then a few weeks before GDPR, we get, and this is an SDK, right? So we are processors of applications. We get a note from Google Play saying, we have identified several hundreds, and I can tell you we were talking about 500, applications who use your tool and do not provide Google-approved consent. Not GDPR, nothing. Google-approved. And this means and they were really nice because they emailed us first. This means that from today to tomorrow, no regulators, no complaints from Max Schrems, nothing, no process. From today to tomorrow, 500 apps, closure. It kills not only the apps, it kills the startup, it kills, so much business. Eventually, so this all had to do with the new consent requirements and has to do a lot with biometrics. Consent requirements by Google called prominent disclosure. So Google, inspired by GDPR, came out and said, if there is something that you are doing in your app that is not related to the functionality of the app, you need to provide prominent disclosure, not in your privacy policy, in addition to your privacy policy. A pop-up, a screen, something. Now, who is to tell what's functional and what's not functional? Google. And don't get me wrong, I like Google. I love Google, by the way. I represent Google.
Who doesn't love Google?
Yeah, I don't think they're wrong. And they've looked at it really, really carefully, and eventually they did nothing. We persuaded them that we were part of the functionality, and it was all okay. But it all was fine. All ends that ends well. That's what they say. But the risk, inspired by GDPR, has nothing to do with the actual implementation and enforcement of regulation. It has to do with private sector enforcement, and that happens instantly, very quickly. It is a fear factor because Google is fearful for the 20 million euros or 4% sanction is a big cloud above Google's head. It's not, we as startups, we would not be the first line of fire, but they are quicker to enforce than anybody else. And luckily, if you have, you can explain, and if you did, like our star of the story here, take care of your privacy issues from day one, and implemented privacy by design and have thought about it thoroughly, you can explain, and you can explain to them as well. Better than you can explain to data subjects that are, you know, trying to make a career out of having the flag of privacy. So to me, that's the number one tsunami coming out of GDPR. Another,
Wait.
and this is going to be very short, because it's the lack of.
Because
So
Michael and I
lack of
still
a
need to flip
threshold.
coins who gets to answer first.
Yeah.
Why? Is there an answer?
No, but
So I think the other part of, and it goes with the same story, there's a lack of threshold. So, and this was debated through, in the process of the coming to life of GDPR, but there is kind of equal treatment of all businesses, and there is no threshold. So theoretically, if you're small and lacking in resources, you're still on the hook, just like Google. So that's another big game changer to me.
so we were running out of time, but you want to comment, so I can't hold you. So, yeah, Michael.
Just to the first point, I would say that the GDPR and the Google reaction to it, which might be panic or hysteria, whatever, is a correction to what has happened before that. So without referring specifically to Google, there have been a few companies, global companies, that were data greedy, and
No doubt.
a bit of common sense does not, has not harmed anybody. How many of you have the flashlight application in your smartphone? Probably everybody. There are a few of those applications. Some of these applications require your location. That is an example for something which is completely unrelated to the function. Why did they do that? Because they could. Okay, so the GDPR now corrects that, and if someone overreacts, as far as I'm concerned, it's a correction to what has been before that.
So Limor is kindly.
I'll just say I agree with Michael. And
Okay, great. So,
I have another smart comment, but
okay, I owe it to it. So, I just wanted to move on to some of the details, because this is not a Google session. Still, it's about the GDPR session, but it's a very valuable point to see reality. But I insist sticking on words. So, let's talk about the definition of biometrics. So GDPR defines biometrics under special categories of personal data. It talks about physical, psychological, behavioral characteristics. It mentions face images. That's quite comprehensive. So let's say I have a website of some conference, and all of my speakers have their pictures in it. That's the old world lingo, pictures. We have to say face images now. Would the GDPR apply? What do you think?
You want to go first?
you get paid for that.
For what? No.
Well, for me,
No.
a facial photo is biometrics.
Yeah, facial photos, as we all know, if you take a picture with my smartphone, you can use it in a biometric application. The resolution is good enough.
Therefore, they're within the definition of biometrics, of biometric data within the GDPR.
Okay.
And within the Israeli law as well. If I don't know if everyone here is aware, but Israel has enacted quite close to the GDPR new privacy security regulations, who state and include biometrics within a category of special sensitive information, and applies more security measures to be implemented. So the Israeli law also views biometrics as facial photos as biometrics. There's even a special article that has refers specific to facial photos as opposed to other biometrics.
So I think there's a big question, and not only specifically with photos. And I think when you read the definition of GDPR, and also when you read, for instance, the forms to register databases in Israel, you may be able to read into the definition of biometrics some kind of intent to use or an applicativity of the data to use as biometrics. So here's an example. And I'm moving away from photos for a second because it's easier. So if you take a voice recording, voice recording is ubiquitous. It's all over. I don't want to go with Google again, but hello Siri, okay? But in any event, so a lot of applications capture your voice, but they don't necessarily capture it for the purpose of or through specific technological means that specific phrase is in the GDPR definition for the application of biometrics. And for instance, for voice recordings, if you only capture the voice recordings and you don't use them as biometrics, there are separate categories for under the Israeli data registrar for the registration. So I would argue that, and I think that it would be, and probably GDPR, not different than in many other cases, has not made this crystal clear, okay? And there could be a question, but as opposed to identifiable information, which rests for many years before the GDPR, and this is not new, on the reasonable ability to identify a person and not the actual identification of a person, with biometrics, it should be a little different because the ability for someone else to take my photo or someone else to take my voice and use it through other means of technology may not be justified enough for me to put this database within a bucket that requires a lot more regulation. And I think if you read the definition and if you read the related lingo, it could be read into it because there is the specific technological processing and there is the lingo of allow or confirm unique identification. So as long as I don't have the specific technological processing, my voice is not recognized. So it will not be unique.
Michael, do you have intent has a bearing on the definition of biometrics?
I do not read intent here in the
No, not
definition,
intent,
right?
but application.
But I do want to go back to the photos because when Naama takes my photo and places it on a website because of a conference or whatever, even though she did not intend to use it in a biometric way, she makes it available to everybody else if it's biometric sufficient quality, etc., which it is today. It makes it available to others to do the biometric processing. Whereas with the voice, it is usually, depending on the context, of course, it is usually kept with the data processor, the entity that collected the data, and does not usually make it publicly available. The definition in the GDPR does include the unique identification, but there is no definition of what is unique identification. In one of the recitals, because as we know the GDPR should be read with its recitals, one of the recitals distinguishes between online identifiers, which are provided by the devices, applications, tools, etc. So I can think of, various numbers attached to our cellular phone, IMSI number, etc. And so it distinguishes between online identifiers and unique identifiers. So we can only guess that unique identifier means, well, unique identifier, that you can identify each of us separately.
So if we touch the unique definition of unique identifying, let's say I use fingerprints in my application, and I decide to create a template using only 4 minutia points. So, and I can argue that that's not unique enough, maybe for one-to-one search, but one-to-one comparison, but not to a one-to-many search in order to identify a person. Would that make me go out of the definition of biometrics regarding the GDPR?
So I think we need to take a more macro approach to these questions and not only the definitions of the legal terms. since privacy protection is about mitigating privacy risks. When there is data that may be used by whomever within the organization or by attackers from outside of the organization, if it's biometric data by potential and may be used by others, even if I didn't intend to use it as biometrics, but it's available and it's possible to use it, then I have to manage these risks because I'm holding biometric data. And perhaps another place where the GDPR is relevant and may give some sort of answer to your second example is the question of encryption and pseudonymization. And I think that's, again, a matter of risk management and of even mathematical calculations sometimes, whether I can argue that the data I'm holding is encrypted, is safe, is pseudonymized in a way that makes it enter the derogations of the GDPR. But when you start that discussion, you have to realize that you're holding biometric information, and then the risk management starts from there.
Okay, we are really running out of time, so let's go to explicit consent. Okay, that's another feature that differs biometrics from other types of information when it comes to the GDPR. It states that one of the circumstances in which you can process or control biometrics is when you get your data subjects explicit consent. So what does it mean explicit? What's the difference between explicit to normal or informed consent? Would you, Michael?
Yeah, so once again, the GDPR does not define what is explicit consent as opposed to other forms of consent. So we might have to wait for some reports of the Article 29 in its new name or some court decisions, etc., if and when they show up. However, I would suggest that explicit consent means, well, informed. That's obvious. I have to understand. Me, the data subject, I must understand what's going on, otherwise how can I, to what am I consenting to? I would argue that the consent should be free, and that means that I have a real choice. Now, when the government collects the data, I don't have a real choice, hence it's a breach of privacy, hence it should meet a constitutional test whether under the Israeli Basic Law or in Europe under their mechanisms of constitutional law. So I would argue it has to be informed, it has to be freely given, and it has to be in the form of opt-in. Now biometrics run into some issues there, because in first enrollment, usually, yes, I'm aware of what's going on because I have to put my finger or I'm asked to take off my glasses and look at the camera or something like that. But in secondary collection of my data, especially with facial images, if I'm just walking in the street and there's a camera with facial biometric capabilities, then I'm unaware in most cases of what exactly is going on. And that's a challenge with biometrics and explicit consent, and I'm not quite sure how that will be resolved.
Well, the WP 29, the European Working Group, has a guideline about explicit consent, and they define that as something that is expressed and confirmed in a written statement. And the examples are
in the digital world, so
email,
statements.
online form, electronic signature. They even recommend a two-stage consent mechanism. And there's
a pop-up, like Adi
mentioned mentioned before. And there are also requirements that there is no tying of conditional consent. So consent has to be free, as Michael said, and not a condition to be able to receive the service. So,
Adi, any comments on that?
Yeah, I think the explicitness from a practical perspective rides a lot on the fact that it's separate than all of the other consents that one gives. So if there are other features that are related to the service and you're obtaining, and there is an additional collection of potentially biometric information, then the outlook on the biometric or any other special category is that the consent needs to be separate than the others. So that would require that pop-up, and that would require something, and a different screen. That's something that is mainly, taken into consideration when building these types of applications.
So I had a plan to talk about territorial scope and all that and adequacy, but we are running out of time, and I did ask you to answer the survey. So. Okay, let's talk a little bit about your opinions. First question was, what personal information do you find most sensitive? And as you can see, that's very interesting. Do you have any comments on that? I can see that, well, health information is the number one, and then financial information, and third, biometrics. But financial information is not a part of the A list of the GDPR, so that's very, very interesting. Do you think the list should be expanded then? Okay.
We should remember some biometrics reveal health issues, right? Kind of, through the retina, you can realize some diseases, etc. So there are interconnections there, at least with health and biometrics.
Also with financial biometrics, you put it protects your fingerprint, protects your.
Yeah.
I think financial information just holds within it such immediate damage. I mean, somebody spending your money, basically. So that's very intuitive, and people think, oh my God, that's going to cause damage. They care a little less in my mind, but some people care more about their, even location, habits.
Consumption habits is
low.
Is low.
I'm happy to see it because to me it's so clear. But
okay. Next question, please. So the second question was, what biometrics do you feel comfortable with? And this is also very interesting to see that fingerprints, people feel, at least in this room, people feel that that's the most comfortable biometrics they encounter. So how about that? I think that consists with what we saw earlier this morning, that we can see a shift between, about 5 years ago, we would say that people feel more comfortable with face images, but now fingerprints just go up ahead. Maybe it's because we're getting used to it.
what do you mean by comfortable? I mean, do you mean that it's okay for me to give my fingerprint, or do I feel that it's more secure?
Means that when you come to work, maybe you prefer that your work attendance will be registered by your finger and not by your face.
I prefer it's not at all.
Not at all.
You're the boss.
Everything is related.
But I don't capture.
What do you think?
fingerprints of
Any comments? Okay, next question was, well, if you're industry, did you go through a GDPR compliance process? And I'm happy to see that 25 said yes, but 17 said no. So get on board, people.
By the way, I would argue the 25 are also in progress, but
Probably.
yeah,
Probably.
it's an ongoing, it's work in progress all the time.
So if the GDPR applies and my company does not comply, what can possibly go wrong? What can happen? Please make us a bit scared.
I think that you should say.
I actually couldn't and shouldn't speak for the
Europeans.
As an Israeli regulator who is not empowered by the GDPR, then I would think that that's a question for European regulators to answer.
But Israeli companies should also be concerned, because the regulator should do what the regulator can do under the current law, and if the law is amended, as there's a pending amendment in the Knesset to strengthen Limor, and class actions, which are not that easy with privacy issues in Israel, but there's a way to get into that in some cases at least, and bad PR. You don't want to make your customers unhappy.
And also before the PR, you don't want to make your customers unhappy, period. And you basically cannot operate. If you provide services to anybody in the general vicinity of finance, general vicinity of health. In the online publishing industry, DPAs, data protection agreements, are bouncing back and forth. I suspect that a lot of people don't even know what's written in them. But in any event, you cannot, simply to perform business and to sign contracts which you believe you materially comply with and materially are not in breach of, you need to have a process in place if you are not a strictly local player.
I also think it's worth mentioning that both GDPR and Israeli new regulation has a breach notification duty in them, something that Americans are used to from the beginning of the 2000s, but it's new in Europe and in Israel. And it means that if you do not comply, and I hope that GDPR and privacy protection compliance is not only signing addendums and creating contracts, but actually implementing a privacy protection plan within an organization and appointing the people and allocating the resources to do better protection, then if you're not preventing breaches, and you have breaches, and you have to report them to regulators and to your customers and to the public, then that's a very intimidating outcome for a company.
So last question, but not least, who do you trust to manage your biometrics? Who do you trust more to manage your biometrics? And, well, maybe if we were French, we would see a different answer. But the government here seems to be in the first position. So, Michael, I know you have something to say about that.
I wanted to say something about a different point, but not about this one. So, as a closing comment,
Okay.
Another issue that I haven't heard about, and I would love those who do biometrics in the business and government to think of, people with disabilities. I think about 5% of the population doesn't have fingerprints for whatever reason, and other people have various other issues. And when the only system to enter a place, for example, is biometric, it remarks, that system remarks their disability in a way which is undignifying to those people. So, and you know, many of us have various kinds of disabilities, so don't forget those people as well.
So we will do the closing remarks and wrap it up. I'm sorry we don't have any time for questions, but I'm sure some of our panelists will hook up with you right after this session, except Limor because she's running away. So Limor, your closing remarks.
I think the most important thing is understanding that it is a work in progress. It's something that